To Division 6 of the Court of Appeals. My name is Tony Navarro. To my right is the Honorable Diana Terry. To my left is the Honorable Robert Kapelke, who we're honored to have sitting with us today. He's one of our senior judges. We have two cases on our 130 docket, people in the interest of S.H.B. and King versus Scheller. We will take a short recess after the first case in order to reconstitute the panel for the second case. Are counsel for the first case ready and at the tables? Looks like you are. I believe you received written instructions with our oral argument procedures, and I know you're both experienced at arguments, but I'll let you ask any questions if you have any. Seeing none, I remind you each side has 15 minutes for argument. Appellant's counsel may try to save some time, but I ask you to keep track of your time with the clock on the lectern so that you could save some rebuttal if you'd like to. I remind both counsel that these proceedings are live streamed on our website, and they will also be archived on the website. So please maintain the confidentiality of any juveniles' names, sex assault victims, and any other information that you don't want publicly released. Also, please identify yourself by name and attorney registration number when you get to the lectern. I ask everyone in the courtroom to turn off any cell phones or similar devices so they will not go off and disturb the arguments. With that, I think we're ready to hear arguments in people in the interest of S.H.B. number 16CA2031, and counsel may proceed when ready.
May it please the court, my name is Mark Evans, number 40156. I'm a public defender here today representing S.H.B., who was a 14-year-old girl at the time of the offense alleged in this case. Colorado sex offender registration statutes are sufficiently onerous and complex that law school-educated adults, much less a 14-year-old, can have trouble figuring out which requirements apply in which situations. And it's in part because of that level of complexity that we have a line of cases holding that if the state charges someone with a crime for violating a particular requirement of the registration statutes, then the state has to prove beyond a reasonable doubt that that particular requirement was violated. Now here the state charged S.H.B. with violating subsection 18.3.412.51G. That subsection required the state to prove that she failed to register upon changing an address. That subsection thus criminalized violating one of the Sex Offender Registration Act's requirements, but it did not criminalize violating the Sex Offender Registration Act's separate requirement that a person must register after ceasing to reside at an address and thereafter lacking a fixed residence. Hence, People v. Jones held that the plain and ordinary meaning of subsection 412.51G requires the state to prove that the defendant moved from a fixed residence at one place to a fixed residence at another place. It's not enough to prove only that the defendant left the place where he or she was registered. Now, the only evidence presented here, even if you credit the minute orders that the trial court improperly took judicial notice of, is that as of August 2015, S.H.B. was not at the location where she was registered. There's absolutely no evidence that she established a fixed residence at some other place and failed to register that changed address.
Mr. Evans, what is your view of what fixed residence means? Does it refer to physical location only? Does it refer to time? What does fixed mean in your view?
Well, Your Honor, when you look at the definitions of fixed residence and residence in the registration statutes, I believe it's section 102, they're not a model of clarity, but I think that really a residence is someplace where you're staying for more than 14 days, and a lack of fixed residence is not having that type of residence, being somewhere for under 14 days. But I think that in both scenarios, you can be looking at either a temporary or, for lacking a fixed residence, it would be a more temporary type of situation. But in any case, the actual requirement in the Sex Offender Registration Act that subsection 312.51G criminalizes is changing an address. And an address is a place where you can be found or communicated with. And that's just the plain and ordinary meaning of the term as recognized by Jones.
Thank you.
That really is the gist of it. And as S.H.B argued at trial, there was no evidence presented that she changed her address, that place where she could be found or communicated with. This case is very straightforward. I'm happy to answer this court's questions about either of the two issues that were raised on appeal, but Jones is controlling here, and under Jones, S.H.B's adjudication should be vacated. So unless this court has further questions, I'll reserve my remaining time for rebuttal.
Looks like not. Thank you, Mr. Evans.
May it please the court, Carmen Morales on behalf of the people. My attorney registration number is 34852. So this court reviews sufficiency of the evidence de novo. Like in this case, it doesn't matter what the trial court as the fact finder relied on. The two officers' testimony together with the prior findings and orders, including the existence of a warrant for the juvenile's arrest, was sufficient to establish that the juvenile no longer lived at the Bryant residence, and therefore that she had changed her address. As it pertains to the interpretation of changing an address, we acknowledge Jones, and which interpreted as moving from a fixed residence at one place to a fixed residence at another place. And well, we're not contending that Jones was wrongly decided. The trial court here did not have the benefit of the Jones opinion, and therefore it is our argument that it could not have been an obvious error for the trial court to fail to interpret changing an address as the Jones court did. And it pertains to the judicial notice. The trial court here under Doyle could properly take judicial notice of prior findings and orders, including the existence of a warrant for the juvenile's arrest, which the court supports it did. And those are arguments, and of course, unless this court has any questions, we're going to rest on our briefs. So,
Would you acknowledge that there was no evidence that she had actually moved to another fixed residence?
yes, Your Honor,
Okay,
there
thank you.
wasn't. So unless this court has any questions? Well, thank you.
It appears we do not. Thank you, Ms. Marlea.
Thank you.
Mr. Evans, I'm not sure there's much to respond to, but you're welcome to have the podium.
Your Honor, I'll come back up here just to make myself available for the court's questions. I think that the preservation issue was addressed in the reply brief. I'm happy to rest on that, or if the court has questions, I'm here. If not, I would respectfully ask the court to vacate S.H.B's adjudication.
Okay, thank you much, Mr. Evans. Thank you to both counsel for your argument. They'll be helpful to our division in deciding the case. The case will stand submitted, and a written opinion will issue in due course. As I mentioned earlier, we're going to take a short recess to reconstitute the panel and come back for our next case. Thank you both. Afternoon again, everyone. Sorry to keep you standing so long. Welcome back to Division 6 of the Court of Appeals. Once again, my name is Tony Navarro. On my right is the Honorable Diana Terry. On my left, joining us is the Honorable James Casebolt. We have one case left on our 1:30 docket, King versus Scheller. I see that counsel are sitting at the table. Looks like you're ready to go. I'm not sure if you were here earlier, so I'll repeat some of my comments that I made earlier. You have received a set of written instructions, or at least you should have received a set of written instructions. Does either of you have any questions? Seeing none, I'll remind you that you have 15 sides, or 15 minutes per side for argument, and appellant's counsel may try to reserve some time. If you'd like, but please keep track of your time with the clock on the lectern. Remind both counsel that these proceedings are live streamed on our website and will be archived there, so please maintain the confidentiality of any juveniles' names, sex assault victims, or any other information that you want to keep private, or at least not on the internet. Please identify yourself by name and attorney registration number when you reach the lectern. I again ask everyone to turn off any cell phones or other similar devices so that they will not disturb the arguments. With that being said, I think we're ready to hear arguments in King versus Scheller, number 17CA1440, and counsel may proceed when ready. Thank you.
Thank you, Judge. May it please the court. I'm George Parker. My Colorado bar number is 21399. I represent the appellants who are the plaintiffs in the trial court. Here's the deal. We have, this was of course a civil case, and the plaintiff sent out some written discovery requests for production of documents, which included cell phone records request for the defendant's employer. The defendant was a COO of a healthcare location up in Johnstown and had a company cell phone. We had a motion to compel the production and a hearing with the trial court. The trial court said, plaintiff, this lady no longer works because she had retired since we sent out our request. Doesn't work there anymore, they can't get it. She can't compel it. You can go out and get it if you like with a subpoena. Okay.
And you did not do so, is that correct?
Then I did not do so. She did not say I could not obtain it through other means. She just said, okay, for this request for production, since she can't hand it to you, you can go get it with a subpoena. The objections to it by defendant was that the client worked for a healthcare establishment, behavioral health care, and that they had a lot of confidential health information and patient phone numbers, et cetera. So what I did was I took advantage of the Colorado Rules of Evidence and said, okay, to myself, I'll just wait, and when I get to court on the stand, I'll ask the defendant, did you ever get the records from your company when you were the COO? Did you look at them? What'd you find?
Wouldn't that have been a hearsay, wouldn't a hearsay objection have been sustained if you had asked that question?
I don't believe so, Your Honor, and let me tell you why. This would have been a party opponent, and it would have been her own, what she saw as a witness.
Well, if it had been something she said, yes, then it would be an admission of a party opponent. But the document itself and what it said would have been hearsay, right?
I don't believe so. I don't believe so because I'm asking the witness what she witnessed. And I believe that I had the right to do so. And the hearsay objection was never raised, so.
Well, you didn't ask the question. So
I'm sorry?
you didn't ask that question at trial.
No, at trial, we had a motion in limine hearing that morning, and the judge came on record and says, you can't ask the lady whether she reviewed the corporate records before she left, and if so, what did she see on them? And that hearsay didn't come up, we didn't discuss it. And the judge never articulated any reason whatsoever as to why we couldn't ask her on the stand cross-examination.
Well, I think we can assume it was because of hearsay, but anyway, go ahead.
Okay, thank you. So The question, and basically what it came down to is this. I believe we had a right, and I hear your concerns about it may have been hearsay. I believe we had a right to ask the lady if she reviewed the records, and if so, what did she find during that review? We weren't allowed to do that. The judge did not explain why we could not cross-examine this witness on this issue at all. I couldn't tell you why she decided it. And I believe that it's important when you have a substantial right, such as cross-examination, that the court articulate their reasonings for denying that right. I believe the case law in my brief and response state that. And anybody have any questions?
I do, Mr. Parker.
Yes, sir.
In order to conduct cross-examination, you have to ask questions that you have a reasonable basis to believe will produce admissible evidence, correct?
Yes, sir.
So, did you not have to show at least some basis to say that the records would have contained information about cell phone usage?
Yes, sir.
Okay, but if she didn't, if she had never seen the records, what would that get you?
If she'd never seen the record, that would have gotten me nothing if I'd been allowed to pursue that in court. If she had seen the record and she says, yes, but I disagree with what it said in it.
Well, let's take it one step at a time.
Okay.
Ask the question, she says yes. What's your next question?
Yes, she has reviewed.
Yes, I've reviewed those records.
What do they say?
Hearsay. How does that get you beyond your hearsay?
I believe, once again, we've got a defendant who observed something, and I believe I had the right to discuss it. Hearsay may have been something, but once again, this is the first it's ever been raised. And certainly a court, could the judge have hung her hat on it? Maybe.
Well, in
But-
order to show that there's been some kind of, you have to usually show some kind of prejudice for the
Yes, sir.
exclusion of evidence. And in order to show prejudice, you have to show it would have been somehow relevant. The answer you would have gotten would have been somehow relevant. So even if
And
she said.
admissible.
Yeah, and admissible, exactly. So if you got the yes response, you still couldn't have said anything further about the record itself because it's hearsay, wasn't it?
Apparently, it sounds that way more and more by the minute. But
Well, I'm
that's
just
not-
trying to show, I'm just trying to understand how you were prejudiced by being precluded from asking the question.
And, Your Honor, let me tell you this. Jurors have a right to, in my opinion, have a right to sit and listen to the witnesses explain things. And when I ask a question like, ma'am, you're the head of the company, and you had a request for production, did you look at the records? She could say, no, I didn't get them, didn't look at them. The question for the jury is why? And it goes to credibility or demeanor.
But how does looking at the cell phone records go to credibility unless you can show that she's lying under oath when she says, I wasn't texting? Don't you have to have some evidence that she was in fact texting, like your client saying she had her head down or she had her head turned or something like that?
And that's interesting because I don't think so. Because you can get evidence from a witness under oath on a stand that you don't have from any other source. And the jury has the right, I believe, to listen to her explanations about why as the head of the company she didn't get them, if they want to believe that. Or she says, yes, I got them, but I don't agree with what they say. Or
Well,
I think the jury has
Let's
that
assume
right.
she says she didn't look at them. What does that prove at all?
If she had
You've
not looked at them?
You've indicated that you think that indicates guilt somehow, that she's at fault just because she didn't look at them. I'm having a lot of trouble, counsel, understanding the logic of that and the ethics of that.
Okay,
Please talk to us about that.
I will. Thank you. Here's the point. If I have someone that says, I don't know what she's going to say. I can just start off with that. I don't know if she got the records, looked at them, didn't like them, and didn't produce them, and fought with me over them. I don't know what she did. The ethics of saying, did you get the records? I did not get them. Well, why didn't you get them? Why didn't you look at them? If someone accused me of being on a cell phone, I would grab my records and I would look at them. And if it shows, no, he was just driving down the highway, I'd slash them up in their face, Exhibit A. I'd be proud of that. And I believe, I never got to get into any of these questions. I believe that had I been able to get into them, I don't know which way it would have gone because we never got that far, and that's my problem.
Well, but her not looking at the records couldn't possibly prove whether she was on the phone or not, could it?
I don't know whether, see, that's my problem. My problem is we
I'm
didn't.
having trouble. There's no logic to that argument as far as I'm concerned.
Okay. I believe that if she says, I got the records and I looked at them, I didn't produce them. The question would be, well, why not? And I think an inference the jury could make is, well, they must have said something you didn't like.
Is that a fair inference? That's a problem that I'm having with your argument, counsel. Is that a fair inference?
The next question wouldn't have been an inference, Your Honor. It would have been a question. Well, what did it show? Was it something you didn't like? I don't know. We never got to get into any of this. We can speculate what she may have done, may not have said, and it could have gone my way, it could have not gone my way, is the point. I believe that the right to cross-examination makes that, it's relevant evidence. There's no doubt it's relevant evidence.
Well, I'm having trouble agreeing with you on that point, counsel.
Well, then there is doubt. I believe cell phone records would have been relevant evidence, whether she reviewed them and whether she agreed with them, didn't agree with them, explained to the jury why. Maybe she says, yeah, it did show I was on the phone. I was texting my sister who she was going to meet for lunch. I don't know. See, and that's why I'm here. I'm here because I believe that you have a right in trial for relevant evidence to explore that on cross-examination with a witness. Just like if I'd have gone out and subpoenaed the hospital and fought with their lawyers over production of those cell phone records, I believe I would have had a right to do that as well.
So, Mr. Parker, I guess I'm returning to Judge Casewell's questions about prejudice. Since you don't know what she would have said and you don't know what the record showed, how could you prove that the absence of this evidence was prejudicial?
You can't. What you can.
So how can we reverse then?
You can reverse it this way. We had the right for cross-examination. We had the right to get into this topic and this subject, in my opinion. I hear that's debatable. We had the right to get into it, and to prove what that cross-examination line of questioning would have shown would have been in my favor, or equally against my client's favor, no one can do, because we weren't able to get there. And that's the problem, in my opinion, is that the trial judge, if you're going to deny someone a right to get into evidence that's arguably relevant, okay, but please go on the record, as the Supreme Court has said, and we can't just assume, I don't think the appellate court should assume, that the judge based it on hearsay, or that the judge, well, it could have shown this, it could have shown that. I would love to know what all evidence in court, especially out of witnesses, was going to be before I ask them questions, but when I don't even get to ask the questions, I think that's the reversible part of it.
Did you make an offer of proof about what the evidence would have been?
Your Honor, and that's under Rule 103. Once a judge rules on the motion in limine, you don't have to make an offer of proof.
Why is that? Usually we can't reverse unless we know from the context what the evidence would have been, or else you make an offer of proof.
Well, and that's, once again, I'm referring to Rule 103 that says once a court makes a definitive ruling on the record admitting or excluding evidence, which was our motion in limine, either at or before trial, a party need not renew an objection or offer proof to preserve a claim of error for appeal.
Renew an offer of proof. That doesn't mean you don't have to make one.
Does not need to renew an objection or offer proof, but that was the motion in limine that was overruled.
Yeah, but that's renewing an offer of proof. You're supposed to make an offer of proof so that we know what the evidence would have been. I'm sorry.
We will agree to defer to the court.
Okay, I'm sorry, I'm not trying to put you on the spot, counsel, I'm just trying to help you. We normally look for an offer of proof in a situation like this.
And I would just ask the court to think about 103.
Thank you.
Thank you.
Thank you, Mr. Parker.
See, I'm leaving quickly.
You have 2 minutes for rebuttal if you end up wanting to use them.
Good afternoon, Your Honors. May it please the court. My name is Ashley Hernandez-Schlegel, bar number 43914, and it is my privilege today to represent Ms. Sharon Scheller in this matter. As you know, this case involves a very narrow evidentiary issue, whether the trial court abused its discretion in precluding the Kings from questioning Ms. Scheller at trial about her efforts to obtain and review her company's cell phone records during discovery. The trial court in no way abused its discretion, as it did not misapply the law, and its evidentiary decision was not manifestly arbitrary, unreasonable, or unfair. Not only did the trial court allow the Kings to ask Ms. Scheller whether she was on her cell phone at the time of the incident, but based on all of the witnesses' testimony and the evidence presented, the jury concluded that Ms. Scheller was not negligent. As you've read in the briefing, this case involves an alleged accident in which two vehicles made a left-hand turn, never made contact. The central dispute at trial was whether the Kings could prove that Ms. Scheller left her lane of travel during a left-hand turn and forced Ms. King's vehicle off of the road. The jury heard from a number of witnesses, including Ms. Scheller, and ultimately determined that the Kings could not prove that Ms. Scheller was negligent in any respect. The jury therefore returned a verdict in favor of Ms. Scheller on every claim. About 5 months prior to trial, there was a discovery dispute hearing at the Kings' request regarding whether or not Ms. Scheller could be compelled to produce her company's cell phone records. The trial court found that while the cell phone records may be relevant for purposes of discovery, such records were not in Ms. Scheller's possession, custody, or control at the time of the hearing, and ordered that if the Kings wanted the records, they should subpoena them. I would note that during the discovery dispute hearing, the trial court did not find that Ms. Scheller had engaged in any improper or evasive discovery conduct, and that was not an issue. During the hearing, the King's counsel represented that he would subpoena the records, and the trial court agreed, given the potential privacy and confidentiality issues related to the records, that she would obtain the records first and do an in-camera inspection.
Is there any indication as to why the records were not subpoenaed?
I do not know, Your Honor.
And was there any indication that a redacted copy of the records were requested?
I do not believe that the records were requested at all.
At all,
The
okay.
goal was to, or I guess the process was that the plaintiff's attorney was going to subpoena the records. They were going to be sent directly to the trial court, and the trial court was going to determine what redactions, if any, were necessary.
So redactions were discussed before
Yes.
all of this? Okay, thank you.
Given that there was no evidence that Ms. Scheller was on her phone at the time of the incident and that no subpoena had ever been served, Ms. Scheller filed a motion in limine to exclude the evidence related to her cell phone records. Ms. Scheller argued that the evidence related to her cell phone usage on the day of the incident, that there was no evidence except for her affidavit saying that she was not on her phone at the time. In that respect, Ms. Scheller argued that the records themselves were not relevant because they didn't have any tendency to make an issue of her liability either more or less probable. Ms. Scheller also argued that any testimony besides her testimony that she was not on her cell phone at the time of the incident would be unduly speculative, given that Daniela King testified during her deposition that she never saw Ms. King or Mrs. Scheller on her cell phone at any time. Ms. Scheller's motion in limine also made a 403 argument stating that if there was some issue of relevance, if there was some remote relevance, that any relevance would be outweighed by the danger of unfair prejudice, confusion of the issues, and the danger of misleading the jury. In their response, the Kings only argued that they had decided, instead of serving a subpoena, that they would address the issue of phone calls and pertinent records with the defendant while she was under oath.
She'd already been under oath because she signed an affidavit, though, right?
She, for purposes of the affidavit, yes. She was never deposed during discovery.
Okay, but I mean, she signed the affidavit under oath.
Correct, Your Honor.
Okay.
I forgot to ask you, counsel, did the motion in limine, did it raise a hearsay objection?
It did not. But learning what the court thinks, I think that's something that I will take
Should
into
have done,
account
maybe.
and learn from and do the next time.
Thank you.
It is critical to note that the trial court, while she did not allow the Kings to go into whether or not Ms. Scheller reviewed her company's cell phone records, they were allowed to ask her whether or not she was on her cell phone at the time of the incident. And she affirmatively testified in front of the jury that she was not. The jury was able to gauge her credibility at that point.
So, counsel, can I ask you a question on that? and this is sort of a hypothetical, had a deposition been taken of your client? And, I mean, a normal question in a deposition is, what did you review in preparation for this deposition? And if she had said, I reviewed the cell phone records, would they not be discoverable at least, as opposed to whether they're admissible or not?
Right, Your Honor. I don't think that that was ever necessarily an issue, was whether the trial court affirmatively ruled during the discovery dispute hearing that they were relevant for purposes of discovery. It would have, if the records would have been subpoenaed, and we would have gone through them, then we would have determined the admissibility or not at that point. But really, we were left with nothing other than Ms. Scheller's testimony that she was not on her phone.
So give me a description of how you think admission of the response to the question at trial, proposed question at trial, would have been somehow misleading or otherwise prejudicial to your client?
I think, Your Honor, that it would have taken away from the actual issue of liability. Whether or not she reviewed her cell phone records or obtained them does not make the fact that she may have turned out of her lane during the turn any more or less probable. So it would have taken the jury away from the actual issue of whether or not she turned out of her lane and said, well, maybe she didn't review her records and therefore she could have been lying. It wouldn't have been relevant, one, but it would have been prejudicial and misleading and then down kind of a rabbit hole that didn't pertain to liability.
Well, the records could have shown whether she was actually using the phone at the time, right?
It could have. But she testified without any impeachment evidence that she was not on her phone. So I think that the speculative question, the trial court properly narrowed the issue, allowed the plaintiffs to obtain any evidence they thought they would want to present and that potentially could be admissible to impeach her, and they didn't.
What do you think of, what's your position? Your learned opponent says that the fact that she didn't review the cell phone records somehow indicates that she actually was using the phone. What's your position on that?
I don't agree with it, Your Honor, because whether or not she reviewed her records doesn't mean that she was on her phone. So I don't think there's really any causal connection between, she could have reviewed her records and they could have said a text came in at a certain time and her phone was still laying on her on the passenger side in her purse. She never was on her phone. So what her records may have said doesn't necessarily lead to she was on her phone at the time of this turn. With respect to whether or not the court should have allowed this, even if the trial court should have permitted a question or two about her review of records during discovery, not allowing it is harmless error. There were a number of witnesses that testified, and including Mrs. Scheller, in which the jury could gauge their credibility and determine whether or not they were lying on the stand or not. Besides Mrs. Scheller and Mrs. King, who were both in their cars, obviously, during the left-hand turn, Mrs. King's daughter was also in the car and testified before the jury. And so the jury had ample evidence to determine whether or not Ms. Scheller, to believe Ms. Scheller's story or Mrs. King's story with respect to the turn. Unless the court has any other questions.
I have a quick question. I noticed you also asked for appellate attorney's fees. Could you summarize why you think we should award attorney's fees?
I think there's, to be candid, Your Honor, I think that the first basis of whether or not this is a frivolous appeal is very difficult for me to prove. I think that the plaintiffs were given the opportunity to obtain this evidence that they're now fighting over to present to the jury if they could admit it, and they didn't. And so this appeal is being brought purely to harass Mrs. Scheller and essentially continue the litigious behavior that we've dealt with throughout this entire matter.
Okay, thank you. Looks like we have no further questions. Thank you, counsel. Mr. Parker, you have 2 minutes and 16 seconds for rebuttal if you'd like it.
You asked me if I wanted it?
It's up to you.
Thank you, Your Honor. Here's here's the deal. I believe it's important for this court to consider when a trial court issues a exclusionary rule, that the trial court articulate the reasons. And that's Colorado Supreme Court has stated, for example, in the Wells case that I have in my brief, despite this policy of deference to the trial court's evidentiary determinations, we may not simply accept the lower court's rulings in all circumstances. The trial court must address any appropriate objection and articulate the reasoning for its decision. And he goes on to explain, tell us what you're doing and why you're doing it. It could have been hearsay. Thank you. But I don't think that's what it was. I think what it was is a judge had the feeling that I could have gotten it through a subpoena, didn't do it, so any other avenues are precluded in trial. And I think that's what this court should consider. We don't know why the trial court judge did what they did. They excluded evidence that was relevant, or it didn't say why they excluded, they just excluded it. And I do believe it's important for people out here in the trial court world trying these cases to be able to understand and present their cases either through cross-examination, through request for production, or any of the other ways you can present evidence in a courtroom. And seeing no questions, thank you. No. Do you have any questions?
Looks like we do not. Thank you, counsel.
very much.
Thank you to both counsel for your arguments. They will be helpful to the court. The case will stand submitted and a written opinion will issue in due course. Both counsel are excused in this case, and that concludes our afternoon docket. The court will be in recess and the bailiff may so announce.